SJC-13788, Andres Hidalgo versus Watch City Construction Corp. and another.
May it please the court. My name is David Belfort, along with attorney Robert Mantell and Nafisa Bora. We represent Mr. Hidalgo. The appeals court punished Mr. Hidalgo when it reduced his fees based on the value of his wage case instead of the harmful SLAPP counterclaims filed by Watch City.
Did you raise that argument before the appeals court?
We did. We
Where?
raised it both on the first page of our brief. It's in your index at page 24.
What, I'm sorry, when I say that argument, did you say that the attorney's fees should, in a determination of whether attorney's fees are reasonable, you should look at the value of the counterclaims?
Yes, we did. We did it on the
And
first
then
page of our...
having preserved that argument, did you then tell the appeals court what the value of the counterclaims were?
We did. Let me dial it back slightly if you don't mind.
Where did you tell them the value of the counterclaims?
We first pointed out that there needs to be a relationship between the SLAPP claims and the harm that those claims pose. On the first page of our brief, we then went through the lodestar method,
Right.
and it's important to note that we then filed. There was no opposition to our initial motion. We filed a motion for reconsideration.
So in
the
your
appeals court.
initial motion, where you argued that the value of the counterclaims should be a factor in determining the reasonableness of attorney's fees, did you submit the approximate value of the counterclaims?
We did not, because we were not put on notice that the court.
You made the argument, you said.
We made the argument that we were successful in our SLAPP claims.
No.
The
argument that the reasonableness of attorney's fees should in some measure reflect the value of the counterclaims.
Well, civil rights claims are extremely hard to value in the first place. We did, when we were put on notice that the court was connecting the Wage Act violation damages to our legal fee award, we did point out to the court that there are two elements of damages that they ought to have focused on. They ought to focus on, number one, the exposure to us of defending the SLAPP counterclaims, and number two, the exposure of damages that would arise as a result of the potential exposure had those claims not been dismissed. At that point, we made an estimate of roughly $220,000 based on all of the case law that we called on similar counterclaims.
That was during the reconsideration process.
Correct, because we
So
weren't on
when,
notice.
at the time you filed for the motion for attorney's fees, you did not give the appeals court a valuation of the counterclaims.
Correct. There's no requirement under the lodestar method that we do that. It's an adversarial process.
I haven't read the background stuff. Did you have your breakdown on how much you spent on the anti-SLAPP versus how much you spent on the Wage Act?
We only filed a petition with the appeals court on the anti-SLAPP work.
Okay, so that was clear that it was all devoted to anti-SLAPP.
It was all. And the court, in fact, said that our time was
that's
reasonable.
That's obvious on the materials you submit, because again, I haven't read the backup material yet.
Right. I mean, I think it's important to note that the court affirmatively found that they did not challenge our time, that they thought it was reasonable, that they did not challenge our rates, were supported by affidavits by prominent lawyers in the community. There was no challenge to the actual underlying petition. After they found our fees reasonable, they then slashed our rate by 50%. And that's the problem here, because number one, they rooted their slashing in the Wage Act claim. And that's grossly unfair, because if you've got somebody who's a laborer like Mr. Hidalgo, who needs to attract lawyers, you cannot fairly root it in the Wage Act claim. If you've got a CEO of a large corporation making...
Isn't it a relevant factor? I understand it may not be a sole factor, But isn't it a relevant factor that how much the claim that you're producing, putting in the counterclaim, it's not even all relevant, you'd think?
Not in a civil rights claim, because the proportionality is to the harm and the chilling effect of these slap counterclaims. We didn't invite this battle. I mean, we filed a small wage claim in district court. What happened to us is this was imposed upon us when these slap counterclaims were filed, and we had no option but to fight them. And then,
So it's I'm sorry, so I'm not confused now. So it's the value of the counterclaims potential exposure, or it's the value of the chilling effect on your client?
it's both.
Okay.
So SLAP, at its core, is intended to allow, under the First Amendment, anybody to go to court and to file a lawsuit. That's a legitimate lawsuit, right? They filed SLAP counterclaims against us. If this court is going to look to the measure of damages, it doesn't look to the Wage Act exposure.
Okay.
It looks to the exposure to us of having to defend the SLAP counterclaims, which are these improper claims. The appeals court found them to be improper under your new
But
standard.
you had mentioned earlier some $200,000
Right.
figure. What is that for?
When the court told us that they are going to consider proportionality, we then filed a motion to reconsider because that's the first time we'd ever heard that.
And so what is that value, 200,000?
Oh, I see. It's partially our defense of the SLAP counterclaims and estimated at $75,000. And it's part the exposure of the damages that might accrue had those SLAP claims proceeded, had we not filed the SLAP motion to dismiss. And then we culled the case law and we looked at malicious prosecution claims and we looked at other similar claims, and we came up with an estimate on all the elements of the damages.
But isn't the stake, sorry, I didn't mean to cut you off.
I think you're going to ask the question I was going to ask. Go ahead.
The stakes are, the anti-SLAP stakes are, one, preventing Wage Act enforcement, we've said, is a societal value, and there's a lot of wage theft out there. So I have trouble divorcing the Wage Act consideration, although I'm not sure the appeals court valued it correctly, because it's not just the $7,000 that's at stake, it's the fact that wage theft is going out there and we want to encourage it. So aren't we valuing fighting off the counterclaim that's preventing the enforcement of the Wage Act? They're interrelated, aren't they? I mean, I'm not saying that it should be, I mean, a small number may be a very valuable claim to bring, and a counterclaim that prevents that may be really important.
Well, it is.
I just don't find the divorce between the two correct. It seems to me it's all related to whether this was a correct amount of money to defend an anti-SLAP case brought in a Wage Act case. You know, they're all related to me.
I think I understand your point, Your Honor, and I think
that was very clear. I apologize.
No, I think I figured it out. So you tell me if I did. But number one is the Wage Act case, the $3,500 underlying claim, is important because the SLAP statute is designed specifically to allow people who earn $3,500 in a full month to go to court and not fear that they're going to be subject to these spurious counterclaims. Right. Because that not only, the next step is that we appeal and we get legal fees for that chunk of the appeal because the district court got it wrong. That appeal was imposed upon us when we were opposed at the district court level by my brother. And so we had to appeal that issue. Again, to get capable lawyers to represent laborers and to discourage employers or corporations from filing lawsuits, counterclaims, to discourage these low-wage earners from bringing these cases. Right. That's the sort of core element of why the focus of the court on the Wage Act amount was wrong, and instead the appeals court ought to have focused on whether the time was fair and reasonable.
Whether a $60,000 legal bill was reasonable in light of the fact that you brought a Wage Act claim that society values, and they brought a counterclaim that made you litigate it, right? That's the state.
Right, at any point they could have dropped it.
Right.
I actually find a lot of this to be confusing to me because, correct me if I'm wrong, was your fee application not limited to fees on appeal?
It was limited to fees on appeal.
That's what I thought. And if that's the case, to the extent that proportionality is an issue, wouldn't we be looking at it in the context of whether your fees were proportional to the work that was done on appeal?
Yes, that's correct.
Okay. So that is the point that I think perhaps the appeals court, where it went astray, was that it was looking at as though the what might be proportional to the defense or prosecution of the underlying claims, as opposed to what is justified in light of the fee request you're making, which is for your fees on appeal.
Yes, Your Honor.
All right. I appreciate that.
Okay. Yeah. So I mean, I think that's the primary way that there was error. Number one is they looked at the wage case instead of the slap impact. Right. They also used the amount of the wage case to reduce our fees by a half. So they not only focused on the wrong claims, but they focused on the amount of the claims, which is a separate, I think, error. And then they also considered proportionality in a civil rights case where it's extremely hard. I mean, we were pressed to come up with numbers, so we came up with numbers. But the way that the lodestar method works in a civil rights case is they look at the amount of hours and they say, all right, you guys spent 5,000 hours doing this appeal. That's too many hours, so we're going to reduce you based on the excessive amount of work you've done, not by linking it to an irrelevant wage claim for a low-wage earner who would have no chance of bringing a lawsuit like this, but for their attracting capable counsel to prosecute them.
Do you think that proportionality is ever relevant when assessing a claim for attorney's fees in a civil rights case?
So in civil rights cases, it can be proportional to the harm of the SLAPP statute. So the deterrent effect is eliminated, those types of things, but they're very nebulous. They're very nebulous concepts. I mean, one of the examples we give in our brief, which I thought was a very good one, was, you know, Rosa Parks, when she paid 5 cents to get on the bus, that's not the rooting event. That's not the basis for her harm, right? And her legal fees, say she needs to be compensated for legal fees. It's not based on the underlying nickel. It's based on the harm that these civil rights violations pose to all of us. And again, it's not a rich and a poor thing. I mean, the CEO who incurs, you know, $100,000 in 1 month of lost wages is also entitled to their full compensation of legal fees. But Mr. Hidalgo shouldn't be punished for that.
But didn't you just say that it should be focused on the amount of time times the amount per hour, right? So it doesn't, whether the, you know, the cost of the indignity or whatever it is, that's not, you're not including that in your ask.
Correct. The lodestar considers the amount of work you did, whether it's a reasonable amount of work given the causes of action, how successful you were. We won on both of our SLAPP claims. The court certainly could have looked at our success and said, had we lost one of those SLAPP claims, look, you only won 1 out of 2, we're going to reduce you slightly because.
But the point I'm just trying to make is we should just be looking at the lodestar. That's how you should value these cases.
Yeah, civil rights cases.
And proportionality could go into the reasonableness of the amount of time that an attorney spent.
Yes.
the weird thing here is that the court specifically found that the amount of time was reasonable.
That's why I think we win, because the court found our time reasonable, it found our rate reasonable, and then it added a factor of proportionality to an irrelevant claim that we weren't before the appeals court on.
Okay, got it.
Thank you all.
Thank you. Attorney Lowe.
Good morning. Thank you, Your Honors. May it please the court, my name is Elliot Lowe, and I represent the appellant in this case, who is Maynor Zepeda. The Watch City Construction is a trade name, not a corporation, and I see that, at least on some of the paperwork, it was identified as a corporation, and that is not correct. Thank you. I think that some of your questions touched on the very issue that is important to consider here, and which is why I'm asking you to deny the appeal here and affirm the fact that the appeals court denied their motion for reconsideration. You asked the questions about whether or not the lodestar method should be the appropriate method to be used in anti-SLAPP. I think counsel talked about civil rights cases. I do not agree that the lodestar method should be the only method that is used when calculating an award of attorney's fees when anti-SLAPP has been violated. Now, the counterclaims in this $3,000 case were for malicious prosecution and abusive process. Those were the counterclaims. At the Waltham District Court, the counterclaim for abusive process, which requires a favorable determination, was offered to be dismissed and then brought later if we got a favorable determination. The judge, after finding that anti-SLAPP didn't apply, then at the appeals court found that it did, meant that at least one of the two counterclaims was offered to be dismissed because under the law, we needed that favorable conclusion to the case. The case has never been tried. The case stopped when the anti-SLAPP issues were raised.
But, I mean, on the issue of attorney's fees on appeal, I think the problem potentially with the appeals court's ruling is that it found that the hours and the rates were reasonable. And then it added this third factor. Yes, I'm wondering, can you address that?
Yes, I'd be happy to. In fact, in the court's order on reconsideration at the very end, it says, it says near the bottom, it says, among other things, the plaintiff is incorrect in asserting that we found that the hourly rates requested by the plaintiff's lawyers were, quote, reasonable, close quote. Rather, we expressly questioned the $425 per hour rate charged for an associate with 3 years of experience, stating that the rate, quote, may be high. So they didn't actually say that everything was reasonable. They did present us with this.
They go further, though. They say the sole reason for changing this is not that. But
exactly, yeah, they do say that.
they go to the next step. And I'm confused by the argument you were making earlier. What are you saying? They won the anti-SLAPP thing. And by the way, you didn't even oppose their fee request, which
Reasons I'd really rather not get into here, but you're right, I didn't oppose it.
you didn't oppose it. The rates are reasonable, the amounts are reasonable. So why go ahead. Why should that not be our guide? Should that not be our lodestar?
Because if you were to rule that the lodestar approach is the only method to be used when calculating attorney's fees in cases like this, you are letting them write a blank check for whatever it is they need to do when
Well, no, because it would go into whether the hours spent were reasonable. I mean, if the case is worth $100,000, maybe it doesn't make sense to spend, whatever, 200 hours times 750, whatever the number is.
When in a case like this, the two counterclaims, abusive process and malicious prosecution, don't require that type. Now, I know what Judge Kafka, you just told me was that we didn't oppose that at the time when,
I just find anti-SLAPP is hard.
It's not the complexity of the malicious prosecution
right.
claim. It's the complexity of the defense to anti-SLAPP. And as we'll see from the next case, this isn't easy stuff.
Well, we know that, and I appreciate that. But the point is that when you are considering whether or not attorney's fees are properly calculated using the lodestar method in a case like this, you are then, if that is the only way that fees can be calculated, you're ignoring the reasonableness of the rest of the case. Now, I know what you say.
No, I don't.
and
I don't.
It's built in.
I understand.
Okay.
Yeah, I was going to say there's a statutory entitlement to reasonable fees for a successful challenge on anti-SLAPP grounds. The statute requires that the successful anti-SLAPP party receive reasonable fees. So unless proportionality can be factored into reasonableness, then proportionality doesn't come into play at all, in my view, because the statute guarantees fees. And so, and since it's in connection with the anti-SLAPP effort, and here the appeal was successful, and they're only seeking the fees for prosecuting the appeal, and I've heard absolutely no argument that $67,000 is too much to spend on attorney's fees for a successful anti-SLAPP appeal. Then how is it, what is the legal framework for considering the monetary worth of the Wage Act claim in that calculus?
There are several cases that have been cited, some out of this jurisdiction, some out of Massachusetts, that talk about 5 or 6 different categories of items that that the courts can consider when considering the reasonableness of a fee.
Were they for appeals? Were they for appeals?
They were not for appeals.
Right, so it's a little bit of a different calculus when it's an appeal, because all you're doing is taking an issue, briefing it, arguing it, right? There's not all the complicated factors that may affect how much time you spend in prosecuting or defending a claim in the trial court. In an appeal, we're looking at a really discrete number of legal tasks that need to be done. So why are we looking beyond those legal tasks in assessing the reasonableness of appellate fees?
Well, your question suggests the answer, because if you're saying that that's the only reasonable way to do it, then that has to be the way to do it. And you're asking me, is there any other way to be reasonable, I think is the import of the question.
Well, no, because I can imagine other ways, right? So you see completely meritless. Let's say someone appeals and there's no basis for the appeal, or the appeal is not successful. You can have lots of factors that would go into the reasonableness calculation when it's fees for appellate work, but none of those factors are present here. At least no one's pointed to them, right?
Right. In this case, the appeal on the counterclaims, the appeal of the dismissal of the counterclaims under anti-SLAPP was the basis for what the fee application was based upon. And what you're asking me is, I think, why should we consider anything since it was deemed reasonable by the appeals court? You're asking me, is there any other basis for us not to allow it? And what I'm saying is, yes, there is. And you asked me what the legal framework would be for my suggesting that there is another basis for doing that. And again, all of the cases that have been cited in all of our briefs suggest that every fee has to be reasonable. And again, by the import of your question, you're asking me, you are suggesting to me that the only method to do that would be lodestar. Number of hours worked, basis for the work that was done, the nature of the attorneys doing it, that sort of thing. And I
But even if we accept there may be some exceptions to using the lodestar, we still have to say whether this exception, which puts a minimal value on the Wage Act claim, is a good reason, particularly on appeal, right? You've got multiple hurdles to get over, not just whether a lodestar is always the answer, whether this exception to the lodestar in this context makes sense, right? You have to convince us of that.
well,
Or at least that it was not an abusive process to do this. Excuse me, abusive discretion. to do so.
yeah, the issue of the reconsideration is, of course, did the appeals court abuse their discretion?
That's your best argument.
And that's what's last here. They did not abuse their discretion. I know counsel has argued, and you have asked some questions about whether or not the appeals court made a mistake by including in their thought process the underlying value of the Wage Act
They
claim.
didn't just include it, they made it central too, right?
They do make it a major factor in their consideration. Yes, they do. And I guess the answer to the question that I'm being asked is, yes, there has to be some consideration given, not just for the lodestar method that is used in connection with calculating the matter here, but in this, since you're asking me about this case, yes, because as I said, the two counterclaims were malicious prosecution and abusive process. We offered to dismiss the abusive process and bring it, if it became appropriate, after the case was decided, if it was decided in our favor. The underlying case involved a Wage Act claim where a landscaper was alleging that he was only paid for 2 weeks instead of 6. And what the district court said to me was, you should have put in your affidavit from the person that we had to show that he only did work for 2 weeks. And because of that, I don't have any evidence to show that you violated anti-SLAPP by filing these counterclaims. So I guess in this case, since we're dealing now with just this case, I would say that clearly, since one of the counterclaims was offered to be dismissed, because the rule actually requires it, that the fee, the reasonableness of the fee in handling that be considered.
But that's not what the appeals court based their
No, they
action
didn't.
on. Okay.
But if this is remanded, I'd be making that argument if they permit it, which I would assume they might.
Counsel, can I just ask you, what is your understanding of what the appeals court did to reduce the reasonableness of the time expended on appeal?
Yeah, there's no question that they considered the underlying value of the case.
Okay.
There's no question about that.
So I understand that your brother made a concession for the CEO, but the problem I have with what the appeals court did is, I think it goes back to Justice Kafker's point. This is symbiotic, okay? It actually makes more sense, to me, it makes zero sense to factor in a low value claim that no one else would bring. And when you say a difference between 2 weeks and 6 weeks to a landscaper, that's a lot of money.
Huge.
It's huge money. And so the idea that the entire basis for why we have anti-SLAPP is we don't want the people that can bear the costs of that thwarting the people that can't. And in this case, he can't bear that cost. So why are we penalizing the folks that need the money most, that make the least amount of money when these things have to be defended? So if you understand that that's the reason why they did that, to me, that makes zero sense.
I agree completely with the analysis and completely with the reason for why this is being done. No question about that.
So doesn't that just mean you lose?
No. No. My point is that the value of the legal fees and the costs of an attorney, and I know Dave Belfort for a while, these are good people. We don't have that issue here. But the question is whether or not this is going to chill not just people who are accused of violating anti-SLAPP like my client has been found to do, but people like my client who are also, this was a counterclaim, who bringing their claims, which those of you who have litigated know that abusive process and malicious prosecution counterclaims until this have been brought fairly routinely. At least the abusive process claims were filed after the fact now, since that changed. But these were common, I don't want to say run-of-the-mill counterclaims, but malicious prosecution claims, when there has been evidence to support it, have been filed routinely. So now, the landscape is changing on that. Whether it's $30,000 or $60,000, which is crazy money to the clients we have, and they don't live in the world that other people live in. And I agree with you wholeheartedly that is the issue here. But the lawyers are not going to not take cases. At least there are lawyers who will take cases when the issue is that kind of a counterclaim and the time spent to pursue an anti-SLAPP on that, especially when one of the counterclaims was offered to be dismissed. That's why I mentioned it, because if you look back to what happened when it happened, that would have meant that there would not have been the necessity to have dealt with one of these counterclaims. That was the reason why I said that. And I think in this case, and if you're making decisions that are going to affect people beyond us, you have to leave the door open for the word reasonableness, which is in every single statute and reported in every single case that we have all presented to you. There has to be that level in here because, just like as you say, that kind of money to the landscaper who is looking for some wages is the same money that my client is being asked to pay for the guy who has X number of landscapers who does landscaping himself and has to feed his family as well. So it is a two-way street. We're dealing with counterclaims here. And that's why I mentioned that that is something that needs to be considered as well. When you're dealing with anti-SLAPP and you're dealing with Wage Act, which also has the mandatory attorney's fees feature attached to that, you have to consider the effect on all the parties. And that is something that should be considered here as well.
Okay, thank you.